We know several conditions can render someone incompetent to enter into a legally enforceable contract. But can someone with such a condition ever be responsible for performing under a contract? The New York case of Fingerhut versus Kralyn Enterprises Incorporated examines this question. Stanley Fingerhut was a successful financial advisor who started a brokerage house in 1967 that was worth $5 million 2 years later. In 1964, Fingerhut was diagnosed with and treated for mixed-type manic-depressive psychosis. He subsequently continued to receive treatment. When Fingerhut decided he wanted to buy a golf course in 1968, he looked into the Aire Golf and Country Club, owned by Kralyn Enterprises. After obtaining an appraisal, Fingerhut, accompanied by his attorney, negotiated with the owners and their attorney. On September 22, they agreed to an approximate $3 million purchase price and executed a binder with the salient terms. Fingerhut also gave the sellers a $25,000 check. 3 days later, a formal contract was developed. The parties signed it on September 26, and Fingerhut put an additional $200,000 down. Fingerhut later initiated various amendments to the contract, and on November 8, he notified Kralyn by letter that he was electing to extend the closing date to December. Around this time, there was also a labor billing dispute related to the contract, in which Fingerhut participated. On November 19, Fingerhut sought to rescind the contract, claiming he was suffering from a manic episode at the time he entered into it and lacked the requisite mental competence to contract. Kralyn refused to rescind the contract, contending that Fingerhut was indeed competent at the time he entered into the contract. Fingerhut brought suit in trial court to rescind the contract and recover the monies he paid to Kralyn. Kralyn moved to dismiss the matter.